This presentation will be an overview of the guidance from the United States Department of Education on the civil rights of students with disabilities concerning student discipline. Resources will be shared along with key points within the guidance. On July 19, 2022, the Office of Special Education and Rehabilitative Services, OSERS, and the Office of Civil Rights, OCR, released a comprehensive guidance package to help schools and early childhood programs in supporting children with disabilities and to avoid discriminatory use of discipline practices. This package provides written clarification from the federal level regarding the removal of students with disabilities from the educational environment, prior written notice to parents, and educational placement decisions. According to the U.S. Department of Education, the purpose of providing the guidance package is to improve the implementation of IDEA so that all students with disabilities are served appropriately and equitably, but specifically to help public elementary and secondary schools fulfill their responsibilities to meet the needs of students with disabilities and avoid the discriminatory use of student discipline. All the resources we discuss will be located on the IDEA New Guidance Help Schools Support Students with Disabilities and Avoid Disparities in the Use of Discipline page, as well as the U.S. Department of Education School Climate and Student Discipline Resources website. The Individuals with Disabilities Education Act, IDEA, New Guidance Package also contains resources to support all stakeholders, including teachers, specialized instruction support personnel, administrators, local education agencies, state education agencies, and families in implementing this guidance. So let's discuss each resource included in the discipline guidance package. First, the U.S. Secretary of Education, Miguel Cardona, provides a letter to educators, school leaders, parents, and students about the importance of supporting the needs of students with disabilities and the impact of the pandemic. This letter shares information about the resources from the department that may be useful in supporting the needs of students with disabilities, including tools for schools to assist students in addressing any disability-based behaviors that could otherwise interfere with their or other students' learning, or that could lead to student discipline or impact safety. The U.S. Department of Education issued this Office of Special Education Programs, OSEP, Dear Colleague letter that serves as an introduction to the guidance package to address disparities in the use of discipline for children with disabilities and the implementation of IDEA's discipline provisions, and two accompanying guidance documents we will discuss later to support state educational agencies and local educational agencies' efforts to fulfill their obligations to appropriately meet the needs of children with disabilities. This letter from OSEP Director Valerie Williams was written post-pandemic and acknowledges the challenges resulting from the pandemic, including mental health and learning loss. She notes that the U.S. Department of Education is particularly concerned with disparities in the use of discipline for children with disabilities and the implementation of IDEA's discipline provisions, which is why they have provided the additional guidance documents to support state agencies and districts in fulfilling their obligations to appropriately meet the needs of children with disabilities. This questions and answers document updates and supersedes the Office of Special Education and Rehabilitative Services guidance titled Questions and Answers on Discipline Procedures that was issued in June 2009 and includes additional questions and answers that address topics that have arisen as the field continues to carry out the discipline provisions of IDEA and its implementing regulations. The letter emphasizes that there is an urgent need for SEAs and LEAs to improve the implementation of IDEA so that all eligible children with disabilities are served appropriately and equitably. Some key takeaways from this letter include, first, data collected under IDEA Section 618 and the Department's Civil Rights Data Collection illustrate the pervasive nature of disparities in the use of aversive practices, such as restraint, seclusion, and in student disciplinary practices, such as suspensions and expulsions, in K-12 schools and early childhood settings for students with disabilities, particularly Black students with disabilities. Secondly, state education agencies and local education agencies should identify ways to better prepare and develop educators, including administrators, teachers, and service providers, to implement effective, preventative, and responsive practices to avoid unnecessary discipline by proactively addressing behaviors that can prevent access to appropriate instruction. Addressing behavior that prevents access to appropriate instruction and to ensure students with disabilities are not subject to avoidable and unnecessary discipline. The Q&A addressing the needs of children with disabilities and IDEA's discipline provisions document includes questions and answers in sections related to these specific topics. Those topics are obligations to meet the needs of eligible children with disabilities under IDEA, an overview of IDEA's discipline procedures, change in placement, interim alternative educational setting, special circumstances, manifestation determination review or MDR, IDEA's requirements for functional behavior assessment, FBAs, and behavior intervention plans, BIPs, provision of services during periods of removal, protections for children not yet determined eligible for services under IDEA, application of IDEA discipline protections in certain specific circumstances, resolving disagreements, and state oversight and data reporting responsibility. It also includes a glossary of key terms and acronyms that are used within the guidance document. The document we're going to be referring to includes that glossary of key terms, and these are important terms to know as you review the information provided. We'll highlight a few of those terms now. Informal removal, although not defined in IDEA and its implementing regulations, means action taken by school personnel in response to a child's behavior that excludes the child for part or all of the school day, or even an indefinite period of time. These exclusions are considered informal because the school removes the child with a disability from class or school without invoking IDEA's disciplinary procedures. Informal removals are subject to IDEA's requirements to the same extent as disciplinary removals by school personnel using the school's disciplinary procedures. Informal removals include administratively shortened school days when a child's school day is reduced by school personnel outside of the individual education program or IEP team and placement process in response to the child's behavior. A disciplinary change in placement or change in placement under IDEA for purposes of removal of a child with a disability from the child's current educational placement for disciplinary reasons means a child with a disability who has been removed from their current educational placement for disciplinary reasons for more than 10 consecutive school days, or that the child has been subjected to a series of removals that constitute a pattern. One, because the series of removals total more than 10 school days in a school year. Two, because the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals. And three, because of such additional factors as the length of each removal, the total amount of time the child has been removed, and the proximity of the removals to one another. This determination is made by the district and triggers IDEA's discipline protections, including a manifestation determination review, and is subject to review through the due process and judicial proceedings. In-school suspension, although not defined in IDEA and its implementing regulations, means an instance in which a child is temporarily removed from their regularly assigned classroom or classrooms for disciplinary purposes, but remains under the direct supervision of school personnel. Direct supervision means school personnel are physically in the same location as students under their supervision. An in-school suspension would be considered a part of the days of suspension addressed in the regulations unless the child is afforded the opportunity to continue to appropriately participate in the general curriculum, continue to receive the services specified on the child's IEP, and continue to participate with non-disabled children to the extent they would have in their current placement. Portions of a school day that a child had been suspended may be considered as a removal in regard to determining whether there is a pattern of removals as defined in the regulations. Manifestation Determination Review, or MDR, under IDEA means the decision as to whether the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or if the conduct in question was the direct result of the LEA's failure to implement the child's IEP, including a behavior intervention plan if required by the IEP. The LEA, parent, and relevant members of the child's IEP team, as determined by the parent in the district, must review all relevant information in the student's file, including the child's IEP and any behavior intervention plan, any teacher observations, and any relevant information provided by the parent. This review must be conducted within 10 school days of any decision to change the placement of a child with a disability because of a violation of the Code of Student Conduct. An interim alternative educational setting, or IAES, as currently defined for purposes of discipline data collected under IDEA Section 618, means an appropriate setting determined by the child's IEP team or a hearing officer in which the child is placed for no more than 45 school days. This setting enables a child to continue to receive educational services so as to enable them to participate in the general education curriculum, although in another setting, and progress toward meeting the goals set out in the IEP. As appropriate, the setting includes provisions of an FBA and behavioral intervention services and modifications to address the behavior violation so that it does not recur. Special circumstances under IDEA means a violation of a code of conduct because the child, 1, carries a weapon to school or possesses a weapon at school, on school premises, or to or at a school function under the jurisdiction of the state education agency or district. 2, they knowingly possess or use illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function under the jurisdiction of the SEA or district, or has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function under the jurisdiction of the SEA or district. Now let's discuss some key takeaways from Section A, the obligations to meet the needs of eligible children with disabilities under IDEA. The section reiterates that the IEP is the vehicle for delivering a free, appropriate public education, FAPE, in the least restrictive environment to students with disabilities. The IEP requirements include assessing, developing, reviewing, and revising the IEP for behavioral supports. This may include the ARC addressing the behavior needs through annual goals, modifications, supports for personnel, supplementary aids and services, and/or related services. Whatever is necessary to enable the student to advance appropriately toward attaining behavior goals. IDEA also requires ARCs to consider the use of positive behavior intervention strategies and other strategies to address the behavior concerns, and this is specifically addressed in question A3. It also goes on to reiterate that an ARC should amend a student's IEP if existing behavioral supports are not effective in addressing a child's behavior needs. The section emphasizes how it is critical that IDEA provisions designed to support the needs of children with disabilities and ensure FAPE need to be appropriately implemented so as to avoid an over-reliance on or misuse of exclusionary discipline in response to a student's behavior. Failure of an ARC to consider and provide for needed behavioral supports through the IEP process may result in a child not receiving a meaningful educational benefit or FAPE. Failure to make behavioral supports available throughout a continuum of alternative placements, including in a regular education setting, could also result in an inappropriately restrictive placement. Not to mention, failure to provide behavior supports and strategies could also lead to behaviors inconsistent with a school or district code of conduct, resulting in consequences such as removals or disciplinary measures. The collection and analysis of behavior data will allow ARCs to make informed student-level decisions when developing or revising IEPs and/or behavior intervention plans. This may include the team developing a root cause analysis in order to take a detailed look at the behavioral patterns to understand what's causing the behaviors or possibly why the current behavior strategies are not effective. The ARC may need to look at not just the student's current strategies, but at the school systems in place. Are positive behavioral systems in place in the school, And how can the school or an ARC team ensure they are used with consistency and fidelity? Section B is an overview of IDA's discipline procedures. So some takeaways is IDA does not define discipline. IDA does explain the rights of students with disabilities and school authority when using exclusionary discipline measures, such as suspension, expulsion, alternative placements. For the purposes of this question and answer, discipline is intended to mean the consequences a school imposes on a child who violates a school's code of conduct. IDA does not prescribe specific disciplinary actions a district must take, but it does set limits. For example, IDA does not preclude a district from disciplining a student with a disability for violating a school's code of student conduct, like any other student. But it does preclude a district from doing so when the disciplinary action results in a change in placement and then is determined to be a manifestation of the child's disability by the ARC. And finally, a key takeaway from this section is that OSEP emphasizes that it is not aware of any evidence-based support for the use of restraint or seclusion as an effective strategy in modifying a child's behaviors related to their disability. And every effort should be made to prevent the need for the use of restraint or seclusion. Restraint or seclusion should not be used except in situations where a child's behavior poses imminent danger or serious physical harm to themselves or to others. OSEP reiterates that the use of positive behavior interventions and supports and other strategies is key to addressing the behaviors of a student with a disability that impedes their learning or that of others. ARC should consider and incorporate into a student's IEP other interventions and supports that are evidence-based to address the behavior needs. Using an evidence-based approach to support and respond to student behavior needs will assist personnel in addressing disparities in and reduce the use of exclusionary discipline. In OSEP's video summary of the Behavior Discipline Guidance Package, OSEP staff provided some considerations to reduce the exclusionary discipline. They suggested that states, districts, schools, and early childhood programs should consider reviewing and enacting policies that restrict or prohibit the use of certain disciplinary practices in particular situations or for particular groups of children. They should also be focusing on preventing the need for exclusionary discipline before it occurs through proactive, systematic approaches while recognizing that there may be instances when a child's behavior, such as if a child is causing physical harm to self or others, warrants possible exclusionary discipline. They also suggest prioritizing the creation of a positive school climate, which fosters safety and promotes a supportive environment with respectful, trusting, and caring relationships. So here are some KD-related resources to assist you with applying those key takeaways we've mentioned so far within the document. Section C discusses change in placement. Some of those takeaways are the U.S. Department of Education explains that exclusions taken outside of IDEA's discipline provisions, which occur because of a child's behavior and result in denials of access to and significant changes in a child's educational program, could be considered as part of the 10 days of suspension and could also constitute an improper change in placement. Those could include when a school administrator unilaterally informs a parent that the student with a disability may only remain in school for shortened school days because of behavioral issues, or when a student with a disability is not allowed by the teacher to attend an elective course because of behavior concerns. These types of actions are generally considered disciplinary removals unless all three of the following factors, or guardrails as we often call them, are met. 1, the student is afforded the opportunity to continue to participate in the general curriculum. 2, the student continues to receive the services specified on the student's IEP. And 3, the student continues to participate with non-disabled students to the extent they would have in their current placement. These guardrails are the same that apply to in-school suspension. The U.S. Department of Ed emphasizes repeatedly throughout the guidance that frequent removals, formal or informal, may indicate an IEP doesn't address needs, which may result in a denial of FAPE. If the parent and district agree to change a placement after a child violates code of conduct, change is not considered removal under discipline provisions. The Department of Ed also notes information on the district making a determination on a case-by-case basis of whether a pattern of removals constitutes a change in placement under the discipline provisions in IDEA. Some more takeaways. The U.S. Department of Ed emphasizes throughout the guidance that frequent removals, formal or informal, may indicate IEP doesn't address needs, which may result in denial of FAPE, and how the use of short-term disciplinary removals or informal removals, if used repeatedly, could be a disciplinary removal. ARCs may need to address whether the IEP appropriately addresses the behavioral needs. In-school suspensions are considered disciplinary removals unless all three of the guardrails mentioned previously are met. However, it is important to recognize that even if the three guardrails are met, an in-school suspension removes the student from their appropriate least restrictive environment, and the ARC may need to consider if the IEP or the implementation of the IEP does not appropriately address the student's behavior needs, and then determine whether additional positive behavioral interventions and supports or other strategies would assist the student in the current placement. If transportation is a related services required for the provision of FAPE and included on the IEP, then a bus suspension must be treated as a suspension, and all of the IDEA's discipline procedures and protections for eligible students with disabilities would apply. In addition, transportation must be provided to a student with a disability who's placed in an IAES if transportation is required for the student to access the services provided in the IAES. However, suspension from the bus is not a removal if transportation is not part of the student's IEP and required for FAPE. Section D clarifies requirements regarding the interim alternative educational setting, IES. IDEA does not define an IES. However, OSEP's data documentation file for discipline data collected under IDEA Section 618 defines an IAES as an appropriate setting determined by the child's IEP team or a hearing officer in which the child is placed for no more than 45 school days. This setting enables the child to continue to receive educational services so as to enable them to participate in the general education curriculum, although in another setting, and to progress toward meeting the goals set out in the IEP. As appropriate, the setting includes a functional behavioral assessment, or FBA, and behavioral intervention services, and modifications to address the behavior violation so that it does not recur. This section of the guidance Q&A clarifies the circumstances under which a student may be placed in an IES and who makes the decision. There are several circumstances under which a student may be placed in an IES. This section of the document also identifies factors that can be considered when determining an IES, including the specific programs and services available in the alternative setting, such as additional counseling services, behavioral and academic supports, and other services or programs that could address the behavior that led to the need for the placement in an IES. If the removal is a change in placement under 34 CFR section 300.536, the child's IEP team, which includes the parent, determines the IAES for the provision of special education and related services. When a removal is a change of placement, as defined in the regulations, services are provided in an IAES following the 10th day of the removal. This situation may occur after a child with a disability has been removed from their current placement for 10 school days in the same school year. During any subsequent days of removal, the public agency must provide services and may do so in an IAES. An IAES also may be considered when a change in placement that would exceed 10 consecutive school days is proposed, and the behavior that gave rise to the violation of the school's code of conduct is determined not to be a manifestation of the child's disability under the regulations. In this situation, school personnel may apply the relevant disciplinary procedures to children with disabilities in the same manner and for the same duration as the procedures would be applied to children without disabilities. However, the child would continue to receive educational services in an IES during the portion of the removal that exceeded 10 school days. Under 34 CFR Section 300.530, school personnel may consider removing a child with a disability from their current placement and placing them in an IES for not more than 45 school days, without regard to whether the behavior is determined to be a manifestation of the child's disability if the child, 1, carries a weapon to or possesses a weapon at school, on school premises, or to or at a school function under the jurisdiction of an SEA or a district. 2, knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function. Or 3, has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function under the jurisdiction of an SEA or a district. The IES definitions and guidance document listed here provides additional information on the factors that could be considered when determining an IES placement. Section E gets into the special circumstances. First, within 10 school days of any decision to change the placement of a child with a disability because of a violation of a code of study conduct, the district, the parent, and relevant members of the child's IEP team must conduct the manifestation determination review. However, regardless of whether the violation was a manifestation of their disability, when the removal is for weapons, drugs, or serious bodily injury, as defined under 34 CFR Section 300.530G, the child may remain in an IES as determined by the child's IEP team for not more than 45 school days. If removed due to special circumstances, the student must continue to receive educational services to allow them to continue to participate in the general ed curriculum, although in another setting, and to progress toward meeting the goals in the student's IEP, and must also receive, as appropriate, an FBA and behavior intervention services and modifications that are designed to address the behavior violation so that it does not occur again. Under IDEA, the procedural safeguards and right to FAPE for a child with a disability must be protected throughout any threat or risk assessment process, including the provision of services during any removals beyond 10 cumulative school days in a school year. Section F. This section clarifies the obligation of the ARC to hold a manifestation determination review each time that a student is removed for more than 10 consecutive school days, and each time that the district determines that a series of removals constitutes a change of placement. This section also explained the 5 W's regarding manifestations determination reviews. Those include 1, what a manifestation determination review is. 2, when must a manifestation determination review be conducted. 3, when a student's behavior must be determined to be a manifestation of their disability. 4, what actions the ARC must take if they determine that a behavior is a manifestation of the student's disability. And 5, what actions school officials may take if the conduct in question is determined not to be a manifestation of the student's disability. If the district, the parent, and relevant members of the IEP team make the determination that the conduct was a manifestation of the child's disability, the IEP team must either 1, conduct an FBA, unless the district had conducted an FBA before the behavior that results in the change of placement occurred, and implement a behavior intervention plan for the child. Or 2, if a behavior intervention plan already had been developed, review the behavior intervention plan and modify it as necessary to address the behavior. The IEP team also must return the child to the placement from which the child was removed, unless the parent and the district agree to a change of placement. In addition, when the removal is for weapons, drugs, or serious bodily injury, Under the regulations, the child may remain in IES as determined by the child's IEP team for the duration of the removal, but not more than 45 school days, regardless of whether the violation was a manifestation of their disability. If the behavior in question was the direct result of the district's failure to implement the IEP, the district must take immediate steps to remedy those deficiencies. When applying the key takeaways from this section, districts may want to review their manifestation determination review policies and procedures with school personnel to ensure clear understanding of the steps involved in the MDR process. That includes understanding what information may be needed in preparation of the MDR meetings, such as current behavior data, teacher observations, teacher collected data, and any relevant information provided by the parents or others with knowledge of the student. In being proactive, the district may want to discuss in advance what immediate steps they may take if the behavior in question was the direct result of the district's failure to implement the IEP. The U.S. Department of Ed reiterates in Section G the IDEA requirements that if the ARC determines that the student's conduct was a manifestation of the disability, the ARC must conduct an FBA and develop and implement a behavior intervention plan. If the district had already conducted an FBA and developed a behavior intervention plan before the behavior occurred, the ARC must review the behavior intervention plan for the student and modify it as necessary to address that behavior. If the ARC determines the student's conduct is not a manifestation of disability, or if the student's placement is a change to an IES based on special circumstances, the district must provide the student, as appropriate, an FBA in behavior intervention services and modifications that are designed to address the behavior so that it does not recur. IDEA requires states to establish and maintain qualifications to ensure that personnel necessary to carry out the purposes of IDEA are appropriately and adequately prepared and trained, including that those personnel have the content knowledge and skills to serve children with disabilities. Districts must ensure that assessments and other evaluation materials used to assess a child are, among other requirements, administered by trained and knowledgeable personnel. In order to meet IDEA requirements and to be proactive in preparing for situations that may occur regarding behaviors, districts should review with school personnel who the properly trained professionals are in the district that may conduct FBAs and how those are conducted. School personnel should also be aware of the district and school-wide positive behavioral interventions and supports that are available for students with disabilities. Section H. This section of the document covers provision of services during periods of removals and reiterates a district's obligation under IDEA to provide services once a child's cumulative days of removal in a school year exceed 10 school days, i.e. beginning with the 11th cumulative day and during any subsequent days of removal. They also clarify who is responsible for determining the services to be provided. The ARC is responsible when the removal constitutes a change of placement, and school personnel in consultation with at least one of the child's teachers when the removal is not a change of placement. Once students' cumulative days of removal in a school year exceed 10 school days, beginning with the 11th cumulative day and during any subsequent days of removal, the district must provide services in accordance with the regulations as described on this slide. So some ways to apply those key takeaways from this section. Review systems in place to document and analyze attendance, behavior, and removal data. Also review district and school plans for providing services in an IES setting for students with disabilities. Section I. This section provides updates and clarifications regarding protections for children not yet determined eligible for services under IDEA. The guidance clarifies when a district would be deemed to have knowledge a student not yet determined eligible is a student with a disability, including if the student is participating in a multi-tiered system of support, such as response to intervention. They also provide guidance on how to conduct an MDR prior to determination of eligibility when the district may have little to no information about the student's disability, and the purpose of the review is to determine whether the behavior is the result of the student's disability. They also address the steps the state education agency and the district can take to ensure that the parents are informed that concerns about the student's needs for special education and related services must be expressed in writing for the disciplining protections to apply. A district would be deemed to have knowledge that the child is a child with a disability if, before the behavior that brought about the disciplinary action occurred, 1, the parent expressed concern in writing to supervisory or administrative personnel of the appropriate educational agency or to the child's teacher that the child is in need of special education and related services. 2, the parent requested an evaluation of the child's eligibility for special ed and related services under IDEA. Or 3, the child's teacher or other district personnel expressed specific concerns about a pattern of behavior demonstrated by the child directly to the district's director of special education or to other supervisory personnel of the district. So what steps can a state education agency and district take to ensure that parents are informed that concerns about their child's need for special ed and related services must be expressed in writing in order for the discipline protections to apply? The guidance reiterates that districts and state education agencies may include in its child fund policies and procedures ways to provide information to the public regarding IDEA's requirements and protections for disciplinary purposes when a parent has expressed in writing to school personnel concerns regarding the child's need for special ed and related services. Some examples of ways to provide such information include making the information available on the state website, the district's website, in parent handbooks, or in the state or district procedural safeguards notice. Districts and schools need to make sure school personnel are aware of the instances in which a district would be deemed to have knowledge that a student is a student with a disability. For instance, participation in a response to intervention process in and of itself would not meet the standard. However, if participation in the response to intervention process is based on the parent or school personnel expressing concern in writing that the student is in need of special ed and related services, and the parent has not prevented evaluation from occurring, then the district would likely be deemed to have knowledge at the time the parent or school personnel expressed their concerns in writings. Districts should review evaluation procedures since once a district is deemed to have knowledge that a student is a student with a disability, the MDR may not be postponed until the initial evaluation is completed or until the ARC is held. The ARC must conduct the MDR, and IDEA does not include an exception that would give the district additional time to complete an evaluation of the student's eligibility. Section J covers the application of IDEA discipline protections in certain specific circumstances. They discuss the specifics regarding how IDEA discipline protections apply to students with disabilities, age 3 to 5, who receive FAPE in preschool settings, whose parents consent to the initial provisions of some, but not all, of the proposed special education and related services in IEP, who attend public charter schools, who receive a free public education in virtual setting, in a correctional facility who violate a facility's code of student conduct, and those placed by a district in a private school or facility as a mean of providing FAPE. The section goes on to discuss who the IDEA discipline protections do not apply to, which includes students whose parents have revoked consent for special education related services and students whose parents have placed them in a private school who are not enrolled in the district and for whom FAPE is not an issue. Section K of the guidance clarifies the steps and process involved for resolving disagreements. The section discusses all options, but two key points include IDEA's dispute resolution procedures are available to parents to resolve disagreements with a district's decision regarding student placement or whether the student's conduct was a manifestation of disability or not. IDEA permits a district to request an expedited due process hearing if it believes maintaining the current placement of the student is substantially likely to result in injury to the student or others. Here are some KDE resources related to resolving disagreements. These are available on the Kentucky Department of Education website. This final section of the question and answer document provides clarification involving state oversight and data reporting responsibilities. The U.S. Department of Ed emphasizes here and within their other documents that the inappropriate use of suspension, expulsion, and other exclusionary removals significantly limits the ability of children with disabilities to receive educational benefit consistent with their IEPs. This section goes on to reiterate the state's role in collecting and analyzing suspension and expulsion data at the district level, including examining significant discrepancies by race and ethnicity. Section L, here are some ways to apply those key takeaways from this section. Districts can examine discipline data to ensure students with disabilities are not being denied FAPE as a result of suspensions and expulsions. You can examine disciplinary removal procedures. And you can examine IEPs and behavior intervention plans to ensure appropriate implementation and effective strategies in place. Again, here are some KDE resources related to oversight and data reporting that are available on the Kentucky Department of Education website. To supporting the needs of children with disabilities, a guide for stakeholders. This document is, as its title reveals, is a 17-page document issued by OSERS that suggests approaches that are considered best practices related to managing difficult behaviors and discipline for students with disabilities. Data suggests that many children with disabilities may not be receiving appropriate behavioral interventions and supports, and instead are being removed from the classroom through disciplinary removals. This resource offers alternative strategies that early childhood programs, schools, and LEAs can use in place of aversive practices or exclusionary discipline. OSEP provides information about resources, strategies, and evidence-based practices that, while not required by law, can help to meet IDEA requirements, and in doing so, improve the outcomes for students with disabilities. We will highlight some of the information and resources you will find within this guidance document. The U.S. Department of Education highlights these 4 key areas within the document for state education agencies and local education agencies to discuss. The document includes many strategies that can be used by schools to enhance their implementation of evidence-based approaches for better student outcomes, and one of those includes multi-tiered system of supports. They highlight universal academic and behavioral supports, targeted supports, and individualized or intensive supports. Next, they emphasize how state and districts need to shift toward a more positive school climate and build capacity of educators, which includes investing time and resources to ensure that their educators are equipped with the skills and support needed to implement the strategies needed in a culturally and linguistically responsive and affirming way. The third key issue that they emphasize is how states and districts need to consider how federal funding is used to address the disparities in and to reduce the use of exclusionary discipline. The document provides information regarding the use of IDEA Part B funds, ESEA funding, Elementary and Secondary Emergency Relief Fund, and Governor's Emergency Education Relief Fund. Finally, the document connects readers to several technical assistance centers that are funded by the U.S. Department of Ed that provide additional resources that can support the implementation of positive, proactive approaches to support the behavioral needs of students with disabilities. This document provides a variety of proactive strategies for consideration. Proactive, systematic approaches that focus on instruction and supports and that are implemented with fidelity and cultural responsiveness are likely to address disparities and reduce the use of exclusionary discipline and result in positive developmental, academic, and behavioral outcomes for all children, including those with disabilities. Those strategies need to support social, emotional, academic, and behavioral needs of students with disabilities. It also encourages stakeholders to consider the harmful effects of inappropriate and ineffective discipline practice and highlights investments that can be made to address the learning and behavioral needs of students with disabilities. The U.S. Department of Ed and Office for Civil Rights also provide the supporting students with disabilities and avoiding the discriminatory use of student discipline under Section 504 of the Rehabilitation Act of 1973 guidance document and an accompanying fact sheet. So this OCR document appears as a 32-page manual with a 4-page appendix that includes a glossary of key terms and acronyms. The fact sheet is a 4-page summary of the extensive information that's contained in that manual. To begin, OCR makes it clear that though it can enforce the rights of IDEA eligible students pursuant to its authority under Section 504, the guidance document addresses the rights and responsibilities concerning a free appropriate public education under Section 504 that apply to Section 504 only students. And that free appropriate public education refers to FAPE under Section 504, unless it's otherwise stated. The United States Department of Education highlighted data in the Dear Colleague letter on the inclusion of behavioral supports in IEP, demonstrating that many children with disabilities, particularly Black children with disabilities, were subjected to high rates of disciplinary removals. Districts can access data on the use of discipline for students with disabilities in the Safe Schools Report and Tableau. More information is located on the Safe Schools data collection and reporting page of the Kentucky Department of Education website. If you'd like to contact the Office of Special Education and Early Learning, you may call 502-564-4970.